Hi there, everybody. Welcome and thank you for joining us for our next installment of Sue Juris, Presenting Yourself in Court. This is video number 6, and today we'll be focusing on pretrial motions. We'll be going over what the practice of pretrial motions involved and what motions are. It's just basically a way of getting the court to move. It's a very precise game, fairly easy to comprehend, but in order to get the judge and the court to act in your case, you have to set forth motions. That's what we'll be focusing on today. How to make a motion, who can make a motion, the basic motion process, frivolous motions, whether a motion is necessary in your case, what goes into a motion, the notice of motion, supporting documentation, scheduling a court hearing on a pretrial motion, serving and filing your documents, court hearings on motions, and then we'll discuss some common pretrial motions such as motion to dismiss, motion for continuance, discovery motions, and motion for summary judgment. So go ahead, get out your pens and pencils and invite your friends, and be sure to share this link because we want to get everybody educated on law. This is how we take back the power, is being able to function as lawful people, to be able to constitute common law grand juries, to be able to issue indictments against criminals, whether they are in government or not, wherever corruption exists. We the people have the power to function as Judge Antonin Scalia, who wrote for a decision for the Supreme Court in 1992, said that the common law grand jury is essentially a fourth branch of government that cannot be infringed by any governmental entities, and that we the people have the power to restore the balance of justice in our land. So let's go ahead and bring up our screenshot for today. There we go. All right, and let's jump right into it. So, pretrial motions are written requests for court orders or rulings by a judge on legal issues. Often, pretrial motions result from disagreements between parties concerning issues that arise in the course of the pretrial investigation or discovery process. For example, the parties to a lawsuit may disagree about whether certain deposition questions one of the parties seeks to ask are proper. If so, the deposing party may file a motion asking the judge to order that the questions be answered, or the adversary may file a motion asking the judge to rule that the deposition questions are improper and therefore need not be answered. Parties also commonly file pretrial motions to attack their adversary's legal claims, often seeking to winnow down legal issues or even to end a case entirely before it goes to trial. For example, either party's motion for a summary judgment may ask a judge to make a final ruling on the merits of a case based entirely on evidence provided in written affidavits, which are statements by parties and witnesses under penalty and perjury, and other such documents. This chapter and video discusses general motion procedures, common types of pretrial motions, and tips for effectively arguing a motion in a court hearing. As is true for other aspects of pretrial procedures, making and responding to motions, which lawyers and judges typically call motion practice, can be frustrating and time-consuming. Don't let it daunt you. If your adversary serves you with a pretrial motion, you'll usually have a chance to respond both in writing and orally in a hearing before a judge. And of course, you may want to file your own motions. In either event, the procedures explained in this video will serve as a general guide to motion practice. However, specific procedures vary from one court to another, so check your local rules carefully before making or responding to a motion. See video 23 for a list of websites that provide court rules. Finally, be sure to consult a legal coach if you have questions. Some motions can dramatically affect the outcome of your case. So let's do an overview of pretrial motion practice. Now, this section provides a brief introduction to motion practice. When do you make a motion? Depending on what you're asking the court to do, a party can make a motion before, during, or after trial. Some motions are made orally and others are made in writing, depending on the rules of court and the type of decision you are asking the judge to make. For example, during trial, parties make oral motions to strike, that is, to delete improper testimony from the record. This video focuses mainly on motions that arise before trial, most of which must be made in writing. Check the rules in your courts to be sure. Who can make a motion? Only a named party to the case, such as you or your adversary, may file a motion. Witnesses or other third parties may not make motions. The basic motion process. Although motion procedures vary from one courthouse or judge to another, the process generally involves these 6 steps. 1, meet and confer. Before filing certain types of motions, especially those related to discovery disputes, court rules may require parties to try to resolve the dispute themselves without involving the court. These rules are generally referred to as meet and confer requirements, even though most courts won't require you to actually sit down face-to-face with your opponent. You can usually meet by phone or through written correspondence. If you are required to meet and confer, try hard to work something out informally, even if it means bending over backwards. Many judges quickly grow frustrated when parties are unable to resolve what seems like trivial procedural disputes. Remember that, as a self-represented party, you are an easy target for a judge's anger, even if you are technically correct. Second part of the basic motion process. File and serve a notice of motion. The moving party, which is the one making the motion or request, called Party A for purposes of this example, serves a written document called a notice of motion on the opposing party, Party B. At the same time, Party A files a copy of this same notice with the court. The third step in the basic motion process is to determine the contents of the notice of motion. Check your local rules to find out what you need to include in your notice of motion, or the moving papers. Because remember, with a motion, we are moving the court along and forward. Typically, a notice of motion will include 1, a statement of the legal issue that Party A wants the judge to address. For example, in a discovery dispute, the notice may state, Party B refuses to respond to my written interrogatories. 2, again, this is the notice of motion will include, secondly, that the ruling that Party A wants the judge to make. For instance, the notice may ask the judge to order Party B to answer the interrogatories and also order Party B to pay me for the time and trouble it took to prepare this motion. It will also include the date, time, and location when the parties can appear in court to argue the motion orally. Party B would generally be entitled to at least 10 days advance notice of the court hearing, but be sure to check with your local court rules about notice requirements. The parties may also forego oral argument or conduct the hearing by phone if the judge agrees. The fourth thing that you'll typically find included in notice of motion is affidavits, something called declarations, sometimes called declarations, which are written factual statements made under oath. Affidavits are essentially paper testimony. They consist of information that the affiant, the person who signs the affidavit, could testify to in court. The affiant must swear that the facts in the affidavit are true and correct, and those facts must concern information that is within the affiant's personal knowledge, such as what the person saw or heard. See video 12 for more information about personal knowledge to be sure what types of facts may properly be included in an affidavit. See also the sample affidavits later in this video. And then finally, you will find in this notice of motion a memorandum of points and authorities, which typically sets forth the statutes or laws, court rules, and possibly cases, which are appellate court decisions, that constitute the legal justification or authority for the rulings that the moving party wants the judge to make. Number 4 of the basic motion process: file and serve in opposition to the motion. After being served with Party A's moving papers, Party B, called the responding party, may then serve and file a written opposition to the motion. An opposition typically presents the reasons the judge should not grant Party A's motion. For example, in the discovery dispute example above, Party B may argue that the discovery questions Party A wants answered are improper, or that Party B has already sufficiently responded to those questions. Like Party A, Party B may also submit affidavits and a memorandum of points and authorities. The 5th part of the process is attending a court hearing. The court may decide the motion without a hearing if the other party doesn't oppose the motion, or if the judge feels that the issue is fairly straightforward. If a hearing is scheduled, it is likely to be a relatively short court appearance, often less than 30 minutes, and will be before a judge alone, no jury. A hearing gives you the chance to amplify what you've said in your papers and to respond to any questions the judge may have. So if you have the option of scheduling a hearing, you may want to take that opportunity rather than rely solely on the papers. When you get to the courtroom, ask the court clerk whether the judge has issued a tentative ruling. A tentative ruling is an informal decision that lets the parties know which way the judge is leaning after reading both sides' written papers before the hearing starts. Though judges have the power to change their tentative rulings, they don't do so very often. If you have an argument that you want the judge to seriously consider, be sure that you put it in your written papers. Now here's a tip. Be succinct. When judges are deciding motions, they tend to move fairly quickly. After all, the judge has probably already faced these issues before in other cases, and may have a long list of motions to decide on the day of your argument. Don't simply repeat, or worse yet, read from the statements you made in your papers. Instead, make your strongest argument or two. Respond briefly to any issues your opponent has raised, and offer to answer any questions the judge might have. Then the final part in the basic motion process, number 6, is to get the judge's ruling. The judge will issue a ruling granting, modifying, or denying the motion. The judge may rule from the bench as soon as the hearing concludes, or you may receive notice of the ruling by mail sometime after the hearing. Motions made during and after trial. These motions can be made during and after trial. Motion in limine. A request for a court order excluding irrelevant or prejudicial evidence, typically made at the outset of a jury trial. We'll get into that more in video 17. Motion to strike. A request that a judge delete improper testimony from the trial record. It's usually made after the judge has ruled that particular testimony is not admissible. Motion for a directed verdict. A request that the judge rule against the plaintiff without letting the matter go to the jury. Typically made in a jury trial after the plaintiff has presented evidence. The usual reason is that the plaintiff has not established the legal claims as a matter of law. And then motion for judgment notwithstanding the verdict, or known as a JNOV, which is a request by one party for the judge to rule against the other party after the jury has already decided in the other party's favor. This motion effectively asks the judge to overrule the jury's verdict. Frivolous motions. A party must have a valid legal basis for filing a motion. Some people use motions for reasons other than what they state in their papers. For example, to delay proceedings or to increase their adversary's costs, perhaps in an effort to force their adversary to drop the case or settle cheaply and quickly. Do not do this. Make sure any motion you bring is truthful and that your request is legitimate. Judges have begun to crack down on frivolous motions, those without a valid legal basis. A party who can show that the other side has filed a frivolous motion may request sanctions, that is, punishment, usually a fine, against both that party and the attorney. If one side files a series of frivolous motions, the judge may even rule that the other side wins the case. If your adversary has acted outrageously in a way that prejudices your case, you can make a motion for sanctions. For example, you may ask for sanctions if your adversary has asked for repeated continuances, seemingly for the purpose of delay or harassment. You might also ask for sanctions if your adversary refused to stipulate and forced you to go to court for continuance, even though you gave an excellent reason, such as your being in the hospital, why the earlier date was not suitable. Like other motions, a motion for sanctions should state what you want and why, and it should include supporting documentation, describing what happened, such as a declaration or affidavit discussed in what goes into a motion coming up soon. For example, if your adversary repeatedly forces you to come to court on frivolous motions, you may ask the court to order the adversary to pay your expenses for preparing and attending those hearings. Caution: don't ask for sanctions unless your adversary's conduct is outrageous. Sanctions are serious business, and most judges do not impose sanctions unless a party's conduct is fairly outrageous. It makes sense to ask for sanctions only in extreme cases and to be sure of the facts before you make the accusations. Is a motion necessary? Before making a written motion or responding to one made by your adversary, try to informally reach an agreement. For example, you need to postpone a deadline. You might ask your adversary to agree to a continuance. If the other side agrees, you can prepare a document called a stipulation to continue. Insert name of what's been continued. Stipulation to continue whatever. Ask the court clerk and check the rules in your court for any special procedures for preparing and filing one. Typically, both you and your adversary must sign the stipulation and file it with the court. If both sides agree, the court will probably grant the continuance without requiring either you or the other party to appear in court. The clerk will then schedule the matter for a later date, as agreed, and notify the parties of the new date and time. A sample of a stipulation to continue a hearing on a motion for summary judgment is shown later in the video. What goes into a motion? Your motions must tell the court exactly what you want and why you want it. Unfortunately, because legal proceedings are rarely that simple, you must put your request and reasoning in the form the court requires and expects. Federal Rule of Civil Procedure 7B governs the form of motions in federal courts. This section discusses documents you typically must prepare in order to make a motion. The notice of motion. A legal document called a notice of motion informs your adversary that you are bringing the motion so that the other side has time to prepare for the court hearing and possibly respond in writing. Your notice of motion should tell the other party, 1, when and where the motion will be heard, the date, time, and place of the court hearing, the grounds, that is, the reasons for your motion, and finally, and thirdly, the supporting documents you will be referring to in your request to the judge, such as points and authorities, that is, written legal arguments that support the reasons for your motion with citations to relevant laws, declarations or affidavits, which are sworn factual statements. The motion. The motion itself is your request for the judge for a specific court order. It states what you want and why you are entitled to that particular order. To justify your request, sometimes it's enough to include a short reference to the rule of law that entitles you to the order, especially for routine matters. Other times, however, especially more complex motions, you may need to list or cite other relevant legal authorities, such as court cases, and explain how those authorities support your position. This type of explanation and citation is called a memorandum of points and authorities. Supporting documentation. As supporting documentation, you may need to include statements of facts in the form of a declaration or affidavit. You may also include copies of other relevant documents as exhibits or attachments. Scheduling a court hearing on a pretrial motion. Some motions are made, responded to, and ruled on by the judge in writing, all without a court hearing. In some courts, motions can be argued on telephone conference calls, but many times a party bringing a motion must obtain a court hearing date for the judge to consider and rule on a motion. The court clerk can tell you how to obtain a hearing date in your court. In many places, you schedule a date by phoning the court. The clerk will assign you a hearing time and enter your case on the court docket or calendar for that day. When you phone the clerk, be prepared to give your case number, your case name and number, the type of motion, and an approximate time you want to schedule the hearing if you have a choice. For example, you might say, yes, this is Sarah Adams, the defendant in Pedestrian versus Adams, case number 12345. I would like a court date, if possible, in about 6 weeks for a motion for summary judgment. Sometimes courts have a particular time or day of the week devoted solely to hearing motions, law and motion day, or special law and motion judges different from the judge who will conduct your trial. When you call, ask the clerk what motions are heard. Caution, double check the judge's calendar. Court schedules sometimes change at the last minute. For example, judges sometimes try to clear their calendars, that is, hear routine or uncontested matters first, then move on to disputed and complex proceedings, or otherwise change their calendars around. It is a good practice to check with the judge's clerk the day before just to verify the time of your hearing and find out how early you should be there. This may have an extra advantage too, of showing the clerk that you respect the courtroom routine and appreciate the clerk's help. Serving and filing your documents. To give your adversary adequate notice, you must often have the papers served at least 10 to 15 days before the motion is due to be heard in court. Federal Rules of Civil Procedure 6C requires notice of at least 14 days for most types of motions. Local rules may have similar requirements. Most courts allow you to serve or deliver your notice of motion and related documents by mail. Federal Rules of Civil Procedure 5A, B, and C, and your state's equivalent govern how service must be made. The papers you serve should include a copy of your proof of service, which is a signed document stating when, how, and on whom the notice was served. Keep a second copy of the proof of service for your records and file the original with the court as required by your court's rules. Here's a tip. You may ask the court for more time to respond to a motion. If your adversary schedules a motion and gives you less than 1 week's notice of the hearing date and time, you may want to let the judge know. The judge may reschedule the hearing or reprimand your adversary, especially if you have not had time to respond or prepare. To protect yourself, Always note the date you received documents from your adversary or the court. Typically, you are not allowed to serve your own documents. Check the rules in your court. Often you must have an adult who is not a party to the lawsuit mail or deliver your documents. The person who actually serves your motion for you is the one who should sign the proof of service. In addition, you must typically file originals with the court. See Federal Rules of Civil Procedure 5D and the rule in your state that governs filing papers with the court. You can file legal papers in person at the courthouse, clerk's office, where you filed your complaint or answer, or you may be able to file documents by mail. Check your local rules and talk to a clerk or your legal coach for other rules, such as the number of copies you must file. You should always take an extra copy to the court and ask the clerk to conform, that is, to stamp the document as filed on the date received, and give it back to you for your files. If you file your documents in person, you can wait for the conformed copy. If you mail the documents, you may need to send an extra copy clearly marked, quote, "Please conform and return to your name and address," with a self-addressed stamped envelope. Court hearings on motions. Before a judge grants or denies a written motion, the judge may hold a brief court hearing. There are no jurors and normally no witnesses, although sometimes a judge will want to hear testimony in connection with a complex motion. But typically, any factual information from you, your adversary, or a witness is presented in the form of a declaration or affidavit, a statement of facts personally observed, dated, and signed under penalty of perjury. Some judges issue a tentative ruling based on the papers you and your adversary have filed a day or two before the hearing. This ruling will indicate whether the judge is inclined to rule for or against the motion, and might state the reasons for the judge's decision. Ask the court clerk and check the court's local rules to find out whether your judge makes tentative rulings and to find out any procedures you have to follow to contest the judge's decision. Caution: find out the rules on tentative rulings. Some courts, particularly those in busy metropolitan areas, require parties to request a hearing if they want to fight the tentative ruling. These courts may have a hotline you can call to hear a recorded message of the court's tentative rulings, or you may have to call the judge's clerk to find out how the judge has ruled. If the tentative ruling doesn't go your way, you can still show up at the hearing and argue your case, but only if you notify your adversary and sometimes the court that you plan to contest the ruling. If you don't give the proper notice, the court will not allow you to present any arguments and will simply adopt its tentative ruling as the final decision on the motion. On the day of your hearing, the clerk will call out the name of your case when it's your turn. You and your adversary will go to the counsel tables to argue the motion. Whoever brought the motion, called the movant or moving party, will usually argue first. After the movant, the respondent, or the party responding to the motion, argues. Both sides make points based on the law and the facts, showing why the judge should or should not grant the request. Because the judge already has documents setting out the parties' positions, it is usually unwise to repeat exactly what is in the papers. The whole hearing typically lasts no more than 10 to 15 minutes. Don't be too surprised if the judge has not read any of the papers you or the other side filed prior to the hearing. Just fill in information where it's needed. And while you may feel pressure to get your points in quickly, make sure you take the time to direct the judge's attention to the most important points or pieces of documentation. Tip: watch a motion hearing before arguing one. A good way to get a feel for how to argue a motion is to watch a motion in the court where you will argue before your hearing. Note where people sit and stand, where the microphones are, how much time the judge seems to spend with people, and what types of questions the judge asks. Also, use any time you have before your hearing begins to review your own notes and observe carefully what the judge seems to expect. Though a hearing is not a trial, you should observe the same formalities when arguing a motion. Stand when you make your presentation and address the judge as Your Honor. Don't talk directly to or argue with your adversary or the adversary's lawyer. At the end of the hearing, the judge will often make a final decision either orally or in writing. Other times, the judge may decide to take the matter under submission. That means the judge will think about it and let you know the ruling later in writing. If the judge makes an oral ruling, take detailed notes to be sure you know its exact terms. Also, make sure you know who is in charge of writing up the order and notifying all interested parties, people who are affected by the ruling. Sometimes the clerk prepares the order for the judge to sign. Other times the judge asks the winning party to draft the order for the judge's signature and notify the other parties of the court's ruling. If you are asked to draft an order, refer to your notes and check with the clerk as to exactly what form the notice should take. One good approach is to ask the clerk for a sample and a list of everyone who must be notified. In many cases, the notice list, names and addresses of the interested parties who should be notified about court decisions in the case, is relatively short. Your adversary and the court. However, a notice list can be quite long. For example, even in the most routine bankruptcy matters, notice of motions must often be given to all creditors, people owed money. Because notice can be defective or invalid, if the necessary people are not included, find out who must be noticed or notified of specific decisions that arise in your case. Do this by checking your state and local rules about notice, or federal and local rules if you are in federal court. Also, if the judge asks you to draft an order, ask the judge's clerk directly who must be given notice. Caution, don't rely on these sample motions. The sample motions in this chapter are illustrations only. To draft or write a motion in your case and be certain you are using the format and language required by your court, refer to your local court rules and a legal form book. Form books, often used by lawyers to prepare motions, also contain helpful explanations of the relevant legal references and factual information called points and authorities you may need to include to support the arguments you are making in your motion. Common pretrial motions. This section focuses on 4 of the most common pretrial motions: motions relating to dismissals, continuances, discovery issues, and summary judgments. It contains sample motion papers and dialogues from court hearings to give you an idea of what may come up when you bring or respond to a motion. Motion to dismiss. If a defendant thinks that none of the plaintiff's claims are legally valid, the defendant can ask the judge to dismiss the complaint before the trial. Essentially, the defendant is saying, even if everything the plaintiff says in the complaint is true, the law says plaintiff isn't entitled to anything from me. The defendant makes this request by filing a motion to dismiss a complaint for failure to state a claim. In some courts, this is called a demurrer, pronounced demurrer, 3 syllables. For example, say the plaintiff's complaint asserts a legal claim of assault, alleging that you gave the plaintiff a menacing look. A look, though perhaps frightening and even rude, does not by itself amount to an act for which the plaintiff can bring a valid lawsuit. Only if you had also taken some threatening action, such as swinging your fist, would the plaintiff have a legally valid claim of assault. If the motion is denied and the judge finds that the complaint is valid, the defendant will have a short time, often another 30 days, to answer the complaint. If the motion is granted and the complaint is dismissed, the judge may allow the plaintiff a chance to amend, that is, fix, refile, and reserve the complaint and summons on the defendant. Motion for a continuance. The purpose of a motion for a continuance is to delay the date of a hearing, settlement conference, deposition, or even the trial itself. For example, if you will be hospitalized for surgery when a motion is supposed to be heard, or if a witness will be out of the country on the date set for trial, you can ask for a continuance. Some courts routinely grant one continuance, especially if the other side does not object. Others want to see a good reason for the delay before they grant a continuance. This may be especially true in courts that have adopted fast-track or expedited procedures, streamlined systems to move cases along at a faster pace than in traditional systems. You may be granted a continuance if a scheduled surgery causes you to be hospitalized, but denied a continuance if you are simply going on vacation. If you cannot reach an agreement with your adversary about a postponement, you will need to tell the judge in your moving papers why the current date is bad. Next, point out that you and the other side have discussed the problem. The judge will likely appreciate your efforts to handle the matter in a friendly way. If you oppose a continuance, emphasize in your opposition papers why a delay would prejudice or hurt you. For example, you may point out that an important witness will not be available if trial is delayed. Or you may argue that the other side appears to be requesting repeated continuances in an effort to stall or force you to settle. For example, assume that you are Sarah Adams, a building contractor whose truck struck a pedestrian, Nolan pedestrian, as he crossed Elm and Main Streets. Mr. Pedestrian has sued you. You are the defendant and are representing yourself. You had barely sent your answer, which is your reply, to the pedestrian's complaint, when pedestrian's attorney sends you a notice of motion for summary judgment, which is a request for the judge to resolve the case without going to trial because the facts are not in dispute. You believe that the pedestrian's attorney is bringing the motion thinking that you will be easily intimidated as a self-represented party and won't know how to respond. You think that the attorney is hoping to get a quick court judgment or advantageous settlement by moving fast before you get a chance to prepare. All you know for sure is that you were not driving carelessly and that you dispute the plaintiff's claim that you were negligent. In addition, you believe that investigation may reveal that the plaintiff's injuries did not come from your truck, but from some pre-existing injury. To oppose the motion, you will need to show that there is a factual dispute that should go to trial. But you need additional time to gather evidence about the facts. So far, you have not had a chance to conduct any discovery or other investigation. You first contact the other side and ask them to agree to continue the hearing to a later date. When you do, they refuse. Keep records of your request and their refusal. You are left with two choices. One, oppose the summary judgment at its scheduled time and date with little evidence to back up your legal position. Or file a motion for continuance of the summary judgment motion so you have time to find at least enough evidence to show that there is a genuine dispute of facts. You decide to file the continuance motion. First, you will need to contact the clerk to schedule a hearing date for your motion. Next, you'll need to draft and file several documents and send copies to your adversary. You will probably have to file with the court and serve on your opponent a notice of motion and motion for continuance. The purpose of these documents is to tell your opponent, in this example, the plaintiff, Nolan Pedestrian, that on the date specified, you will formally ask the judge to delay the date on which the plaintiff's motion for summary judgment will be considered and to extend your deadline for responding to that motion. You will also need to support your motion for continuance with a legal brief, sometimes called a legal memorandum or memorandum of points and authorities, that tells the courts why you believe you deserve the continuance and what legal rules give the court the authority to grant your request. A sample draft memorandum of points and authorities follows the sample notice of motion and motion below. In this case, you will also need to attach a declaration, which is a sworn factual statement that tells the judge why you do not yet have the evidence you need to oppose plaintiff's motion for summary judgment. Pedestrian is asking the judge to decide the case as a matter of law and is claiming that you both agree on the key facts. In your declaration, you will have to identify facts that you believe are not agreed on and indicate what steps you plan to take to gather evidence that will help you prove it. For example, in the sample declarations of Sarah Adams, below you, Sarah Adams, state that you intend to send interrogatories to the plaintiff and to take a deposition of witness Cynthia White. After the sample declaration of Sarah Adams, you will find a proof of service by mail which provides that the defendant sent copies of these documents to the plaintiff's lawyer. Following these sample papers, you will find samples of the documents that plaintiff Pedestrian might file in opposition to the motion for a continuance. The date for the hearing on the continuance motion arrives. You arrive in court a few minutes early, dressed in a business attire. You check in with the clerk, giving your name and the case number and name and number. You then wait until your case is called. Finally, you hear the clerk say, or judge say, Nolan Pedestrian versus Sarah Adams are the parties present. If you and your adversary have both checked in, the clerk may tell the judge that you are here. You both stand to signify your presence. When the judge calls or motions for you to approach, you take your places at your respective counsel tables. In this instance, you are the moving party, the one making the motion, so you will likely be called on first. Typically, the judge will ask what you have to say. Here's what might follow. You, the moving party, speaking. Good morning, Your Honor. I am Sarah Adams, the defendant in this matter. I'm a building contractor here in this city, and I'm representing myself. The reason I am requesting a continuance is simple. The plaintiff scheduled a summary judgment motion 2 weeks after my answer was filed. I have not had time to thoroughly investigate the case. I plan to serve interrogatories on the plaintiff. I will also probably take one or more depositions. I feel strongly that once I have investigated more thoroughly, I will be able to demonstrate that I was not careless. The judge may reply, this is not trial, and I don't want to hear arguments or testimony. And then you responded, Your Honor, I was merely trying to say that I think that I will be able to show very soon that there are significant factual disputes, but I need more time. This summary judgment motion is premature, and having to go forward with one now would unfairly prejudice my case to a fair hearing in this trial. As you see by the judge's comment, the judge may interrupt to ask questions or steer you towards the proper issues. Here, the judge may continue with questions about the discovery you plan to take, the facts as you know them right now, or whether you have tried to get the opposing party to stipulate to a continuance. The judge may also turn to your adversary, judge speaking. What are your objections to such a continuance? Your adversary speaking, the responding party. Your Honor, as stated in our papers, we feel the defendant has had ample time to conduct discovery. We have not been served with any interrogatories or received notice about any depositions. We don't believe the defendant really intends to conduct any discovery. The defendant just wants to try to keep this matter pending as long as possible to force a settlement. My client is injured. Judge, do you have a response? You speaking. Well, yes, Your Honor, that is simply not true. I have no hidden agenda of forcing a settlement. I just want to be treated fairly and have sufficient time to prepare. My adversary is represented by counsel, but I am not a lawyer and I am not as familiar with all of the legal proceedings. I have been working on interrogatory questions and will get them out as soon as I possibly can. Just 60 more days, which can't possibly hurt them, would be most helpful for me to get the facts straight and know how to respond to the summary judgment motion. Judge speaking. Motion granted. Defendant will have an additional 60 days to respond to the plaintiff's summary judgment motion. Now, if the judge rules your way, don't allow your elation to get in the way of your need to clarify some key information. You need to record the exact date and time to which the hearing is continued and find out whether, as the victorious party, you will be responsible for preparing the court order. That is, the document signed by the judge that officially changes the date of the hearing. If what you want is very simple, prepare a proposed order and present it to the judge after you get a ruling in your favor. Discovery motions. If problems arise during discovery, you or your adversary may need to go to the judge with a motion asking the court to order the other side to comply with discovery requests. If you send interrogatories, for example, and your adversary refuses to answer one or more of them, you can file a motion asking that the judge compel an answer, a motion to compel. If a party that is ordered to answer still refuses to do so, the judge can impose sanctions or a fine or hold that party in contempt of court. Contempt of court usually means imposing a fine or even a short jail sentence on the party that continues to refuse to comply with a court order. The flip side of a motion to compel is called a motion for protective order, asking the judge to allow you not to answer certain questions. In federal courts, these orders are allowed under Federal Rules of Civil Procedure 26C and 30D. A party can seek a protective order if the other side's discovery request causes undue annoyance, embarrassment, oppression, expense, or if the other side is seeking privileged or otherwise confidential information. Here's a tip. Try to get your adversary to agree before you file a motion. Before filing a motion to either compel a response to discovery or to get a protective order to avoid having to respond to discovery, try to reach an agreement with your adversary. For example, if your adversary doesn't respond adequately to your interrogatories, don't rush into court. Instead, try to work out the problem, perhaps by rephrasing the questions. You might even write a formal letter setting forth why you believe you have a right to the information if they are objecting, or why you feel you should not have to reveal the information if you are objecting to your adversary's discovery requests. A persuasive letter indicates that you mean business and are not willing to drop the issue, and it may resolve the dispute. And if your negotiations ultimately fail and you eventually bring a motion, the letter, which you can attach as an exhibit to the motion, shows the judge that you attempted to resolve the matter without costing the court time and money, but that the other side simply refused to cooperate. You may want to consult your legal coach before answering questions to see if they are improper, but it is generally improper to ask questions that do any of the following. 1, force someone to reveal a confidential, privileged communication, such as a statement made to a lawyer during a lawyer-client consultation, to a doctor during medical examination, or to a spouse. Secondly, it's improper to ask questions that require an enormous amount of time, money, or other resources to comply with. For example, if you are a small business owner asked to produce every piece of paper you signed having to do with your employees for the past 3 years, you could ask your adversary to confine the request to a shorter, more relevant time period, or otherwise narrow it. It's generally improper to ask questions that harass your adversary rather than discover some admissible evidence. For example, a question about sexual history or possible past criminal record. And then finally, it's improper to ask questions that ask for information that's not relevant to the case. Although the standard for relevance in discovery is much looser than in the trial itself, neither you nor your adversary can seek information about matters that are totally unrelated to the case. Federal Rules of Civil Procedure 37 and your state's equivalents govern discovery disputes. If the court finds you have shown good cause for a protective order, the judge can help you out in a variety of ways, from blocking your adversary's entire discovery request to limiting the people who must attend a deposition, sealing or keeping confidential out of the public record the discovery, or otherwise narrowing the request. Here's a tip. Resolve discovery disputes with a phone call if you can. Because discovery problems are frequent and going to court to resolve them is expensive and wasteful, many courts have established a phone conference procedure so that a judge can quickly resolve such disputes. Check with the court clerk or your judge's clerk to see if such procedure is available in your case. If you are initiating a motion to compel, you probably need the information and believe your request is reasonable. Your papers must tell the judge why this is true. Usually, this means explaining that the request will lead you to relevant evidence in your case, and that it will not hurt or unfairly prejudice your adversary to reveal it. If you are opposing your adversary's motion, you need to give the judge a good reason why you should not have to turn over the information requested. For example, on the contrary to the arguments above, the information is totally irrelevant, privileged, or unfairly prejudicial to your case. For example, say a request asks you to describe each and every conversation you've had with your business partner, Edwin, during the past 10 years. Especially if you and Edwin do business on a daily basis, putting together the description requested would be nearly impossible. In this case, you will at least want to have the request narrowed down. Here's an example of oral arguments in the case of the auto accident at Elman, Maine, Nolan Pedestrian versus Sarah Adams. This time, assume that you are the plaintiff. You were crossing the street when the defendant's truck hit you. You were trying to prove that the defendant, a building contractor, had gotten a phone call reporting a missed job site inspection just before the accident occurred. At trial, you plan to argue that the call caused her to be distracted and drive carelessly. As part of your discovery, you have requested these documents. 1. Records pertaining to all other traffic accidents in which she has been involved, to see whether she has had other similar accidents. 2. Business books and records from her business to determine how common missed inspections are and how much money is at stake because of a missed inspection. And her phone bill for that month to verify the exact time the inspection phone call was received. You serve defendant with a request for production of documents asking for driving and business records. She refused to produce these documents because she's represented by a lawyer who's trying to bully you. You get the feeling they think that if they refuse your discovery requests, you won't know what to do and may just give up without fighting. But you have confidence in yourself, so you fight back. You bring a motion to compel the production of the requested documents. Before you can go to court, of course, you have to get a hearing date and draft, file, and serve your motion to compel, as described earlier. When your hearing date arrives, after you check in and wait for your case, you may proceed as follows. Judge speaking. Mr. Pedestrian, I've read your papers and you have undoubtedly seen my tentative ruling. I'm inclined to grant your request as to the business records and phone bill and order Ms. Adams to produce them immediately. But I'm going to deny the driving record request. Do you wish to add to your written arguments? You speaking. Yes, Your Honor. I would ask that the court also order the respondent to produce the driving records. It is essential to my case to see how many other people have suffered from her negligence in the past. Judge, turning to the respondent or the defendant. Do you have any response? Mrs. Miller, the defendant's attorney. The respondent. Yes, as Your Honor knows, such evidence, even if it existed, would be inadmissible evidence of prior acts, not to mention irrelevant to what happened on the day of the accident in question. We should not be required to produce the driving record now or ever, and we strongly urge that your tentative ruling may be made final as to that issue. For more on why such evidence would not be admissible in court, see video number 16. Judge speaking. So ordered, Miss. So ordered. Miss Adams does not have to produce her driving records. Now, as to the business records and phone bill, respondent, do you have any good reason why the movant should not be allowed to inspect these? Again, Your Honor, these records are irrelevant to the case. My client's business had nothing to do with the accident. The plaintiff ran in front of my client's truck. She tried to swerve, but, Judge speaking, this is not the trial. I'm not going to hear evidence today. Your client has her version, and the plaintiff has his. Unless you can tell me why he should not be allowed to fully investigate his theory, which includes reviewing your business records, I will order you to produce them. Ms. Miller, Your Honor, even if you were to believe my client's business records are relevant, which we contend they are not, the plaintiff's request is too broad. He has asked for all my client's business records from the past 5 years. If he is really just concerned about the cost of missed inspections, then at least we would ask that you limit the request to those inspections we missed during the month of the accident only. Otherwise, their request will put my client out of business. She'll have to spend all her time going through back records and will lose many new projects because of it. Judge, turning to you. Any response? You speaking. Nothing I haven't written in my papers, Your Honor. The defendant's business records are essential for me to prove how much the fact she missed an inspection that day distracted her and caused her to be careless. We must look at 1 year's worth of figures at the very least to make an accurate. Judge speaking. Okay, I will allow the request, but limit it to the 6 months before the accident and to only those documents directly related to missed site inspections. Movant, will you draft the order and give notice? You. Yes, Your Honor, I will prepare the order. To follow up on exactly how the order should read, you might say something like this. Your Honor, could you please review your exact order and possibly have your clerk give me a sample? I have never prepared an order and I want to be sure it is correct. Judge speaking. The clerk can assist you as to the format, and again, my order was that your request for the driving records is denied. The request for the phone bill was granted, and the request for the business records was granted in part. Defendant is ordered to produce all business records pertaining to missed inspections in the past 6 months and the phone bill in questions. Next matter on calendar, Jack versus Jill. Motion for summary judgment. One of the primary functions of a trial is for a judge or jury to decide which party's account of the events leading up to a lawsuit is accurate. If you can show that the important facts are undisputed and that those facts entitle you to a judgment in your favor, you may want to file a motion for summary judgment. A summary judgment motion asks the judge to decide the case in your favor based on the information contained in your motion. If the judge grants your motion, you win the case on the papers without it ever going to trial. The judge's decision carries the same weight as a verdict following a full-blown trial. In other words, summary judgment happens instead of trial. If a judge decides the case in your favor on summary judgment, you win the case right then and there. If the judge denies your motion, the case continues on to trial unless it settles first. By the same token, if your adversary files a motion for summary judgment, you may have to oppose it to avoid losing without having the opportunity to go to trial. You can appeal a judge's granting of your opponent's summary judgment motion just as you can appeal an adverse judgment following a trial. For more info about the appeal process, see video 20. Tip, try to settle the case before filing a summary judgment motion. Before going to court on a motion for summary judgment, you should try to settle, especially if you and your adversary agree on the most important facts. This may be a good time to resolve the case without either of you having to spend the time or money it takes to go to court. You may also consider filing a motion for summary judgment if you can show that the adversary's evidence, even if believed, is insufficient to support one or more of the essential elements of the legal claim. See Federal Rules for Civil Procedure 56C. which provides for summary judgment when, quote, there is no genuine issue as to any material fact and the movement is entitled to judgment as a matter of law. For instance, assume that Mary sues you for a breach of contract. You are a wholesaler, and Mary claims that you failed to deliver merchandise that she planned to sell at retail. Though you disagree with Mary's claim that you and she had finalized a contract, you have learned through discovery that Mary was able to get the same merchandise from another wholesaler at the price and on the schedule that she claims you agreed to. Because Mary has the burden of proving damages, and you can show that any failure on your part to deliver merchandise did not harm her business in any way, you should file a motion for summary judgment asking the judge to decide the case in your favor. See video number 8 for more information about essential elements of legal claims. Caution, lawyers may file summary judgment motions to intimidate self-represented parties. For instance, your opponent's lawyer may claim that no facts are in dispute when plenty really are. Don't fall for this. Assess the facts on both sides, and if you continue to believe that you have a genuine dispute about what happened, fight the motion by filing opposition to the motion for summary judgment. Include in your opposition a written description of the factual disputes that you believe exist, supported with as much evidence as you can muster in written affidavits or declarations. You may want to stress the legal policy favoring a party's right to go to trial, clearly explaining why a trial is needed to resolve the factual disputes. For example, let the judge know that a trial is necessary because a witness whose affidavit your adversary counts on is biased and has made conflicting statements about what has happened. Summary judgment can be an especially cost-effective and useful tool if your dispute centers around a written document, such as a lawsuit for breach of a written contract. The judge can review the written contract, assess both parties' written affidavits and arguments, and make a decision. Cases that may not be as well suited to summary judgment are those in which a judge or jury needs to decide what someone's intentions were or whether to believe an important witness. It may be harder to make a fair and accurate decision on the papers in such a situation because the judge has no opportunity to observe witnesses and evaluate their demeanor and their credibility. Like other motions discussed in this chapter, a motion for summary judgment typically includes a notice of motion and motion, a memorandum of points and authorities, affidavits or declarations, which are sworn statements providing relevant information based on first-hand knowledge, and contracts or other exhibits, such as helpful answers in a deposition transcript or responses to written interrogatories. You will have no opportunity to put on or cross-examine live witnesses. Some jurisdictions also require parties to submit a statement of uncontroverted facts, a document that lists each important fact that the parties agree on, as well as the exact source of evidence that points that fact or that proves that fact, such as the page and line number of a deposition transcript in which a witness testified to a fact. You will probably have to attach copies of any documents or testimony that you rely on to prove these facts. For example, if you state that your opponent admitted a crucial fact in deposition, you must attach the pages of the deposition transcript containing the admission. Be sure to check your court's local rules to find out exactly what must be included in either a motion for summary judgment or in an opposition to the motion for summary judgment. Courts are very fussy about these motions, and it's important to follow the procedural rules. If you want to go to trial and do not want the judge to make a final decision based on the papers alone, you will be the party opposing summary judgment. To oppose your adversary's summary judgment motion, you must show that one or more important facts are disputed, or that a court hearing is required to evaluate crucial evidence. For instance, if you contend that a fair decision in the case depends on whose version of events the court believes, you will want to stress that the credibility or believability of particular witnesses is important, and that the only way to properly determine who to believe is to see and hear the witnesses in person. If you are opposing a motion for summary judgment, your most important job will be preparing an opposition to your adversary's statement of uncontroverted facts. Generally, you should go through your adversary's statement fact by fact, admitting those that are not in dispute and contesting those that are. For example, if your adversary says the defendant was driving a white Ford Pinto on Main Street at approximately 3 p.m. on May 5th, defendant ran a red light at corner of Main and Main Street and Avenue A, you might admit that you were driving the car at that time and place, but dispute that you ran the red light, including evidence to back up your version of any facts you dispute. In the above example, you might refer to your own affidavit in which you state that you did not run the red light, or you might refer to the deposition of a witness who testified that you appeared to have the green light when you crossed the intersection. Pros and cons of filing a summary judgment motion. Like most things in life, filing a motion for summary judgment has benefits and disadvantages. Consider these pros and cons carefully before you decide to file. Potential benefits. Your dispute may be completely or partially resolved long before trial would take place, thus saving you time and money. 2. Helpful witnesses may be unavailable by the time your case goes to trial, but if they are willing to sign a declaration that you attach to your summary judgment motion, you can present their testimony to the judge in written form. If your witnesses are likely to be nervous when testifying orally in court, the evidence that they provide may seem more impressive in a written affidavit than if they were to testify at trial. And finally, final potential benefit is even if a judge refuses to grant your motion, the motion may emphasize weaknesses in your opponent's case, which may in turn lead to a more agreeable offer of settlement. Some potential drawbacks. A motion for summary judgment takes time to prepare and can be complex because you have to include not only declarations, but also legal arguments in a supporting memorandum of points and authorities, or legal memorandum. And another drawback is that you and your witnesses' declarations may reveal information that your adversary doesn't know about, thus giving your adversary time to prepare to oppose it if your motion is denied and the case goes to trial. Also, if a witness's trial testimony differs from what the witness said in a declaration, your adversary can offer the declaration into evidence at trial to cast doubt on the witness's testimony. Partial summary judgment. If you and your adversary don't agree about everything that happened, but agree on the key facts relating to a specific legal claim, that claim may be decided on a motion for partial summary judgment. If the judge grants partial summary judgment, that claim is resolved and only the remaining claims would be decided at trial. For example, assume that your adversary sues you for breach of contract and defamation. If appropriate, you might file a motion for partial summary judgment asking the judge to decide the defamation claim in your favor. If the judge grants your motion, only the claim for breach of contract would remain to be tried. Partial summary judgment can save both time and money because any trial you do have will be shorter. Moreover, partial summary judgment often pushes adversaries towards settlement. Here's a caution. It depends on what the meaning of is. When you draft declarations or affidavits, write your facts in a convincing manner, but be very careful not to shade the truth. Declarations are paper testimony. In other words, just as at trial, declarations are made under penalty of perjury, and they must be based on personal knowledge. If you submit a declaration that includes a statement not based on your personal knowledge, the judge will probably just disregard that statement. But if you submit declarations that contain false or misleading statements, you risk sanctions or worse. And if you have to try the case before the same judge who decides your motion, you will be digging yourself out of a very deep hole for your lack of candor. Before trying to draft a declaration, you may want to refer to the sample declarations and study the material on personal knowledge in video number 12. If you refer to information contained in a different document, be sure to attach a copy of the relevant portion of the document so that the judge can quickly and easily find the source of your information. For example, in the sample declaration of Sarah Adams below, Adams attaches a document that supports a statement she makes in her declaration. Below are sample motion papers and declarations that parties might file in support of and in opposition to a request for summary judgment. The sample forms are accompanied by a transcript of the courtroom hearing that might take place in conjunction with the summary judgment request. The sample forms and hearing transcript relate the plaintiff seeking summary judgment in the sample case discussed earlier, the car accident in which a pedestrian was allegedly injured after being struck by the truck of the defendant, contractor, Sarah Adams. In the sample dialogue that follows, Sarah Adams, who is representing herself, is opposing the plaintiff's motion. Judge speaking. I have the plaintiff's summary judgment motion and the defendant's opposition to that motion here. Unless you, Ms. Adams, can tell me why I should not, I intend to grant the plaintiff's motion and decide this case as a matter of law based on the facts presented to me. It seems to me that the facts are not disputed and that it is in the interests of efficacy or efficiency and all parties involved for me to decide the legal questions now without proceeding to trial. Adams. Your Honor, it is true that there is some evidence we both agreed to. We both agree that my truck hit the plaintiff at Elm, Maine. But there are several other very important facts about which we don't agree. First, the plaintiff was injured only slightly by my truck. According to Dr. Evans' affidavit, which I've included in my opposition papers, the plaintiff's serious injury, the one he really wants money for, was a pre-existing injury. The plaintiff's declaration states that injury was caused by my truck hitting him. We clearly have a fact dispute, and Your Honor, or the jury, if you will have one, must listen to all the evidence and decide who is right. Second, the plaintiff contends that I was distracted and not paying attention to the road at the time of the accident. But as I submitted in my sworn declaration, this is not true. I was driving especially carefully at the time because I had expensive kitchen cabinets in my truck. My statement shows that I was only going 15 miles per hour. Then, without warning, the plaintiff dashed out from between two parked cars. These are crucial questions of fact, and they need to be decided in trial. Plaintiff's attorney, Ms. Charles. By way of response, Your Honor, you have all the facts necessary to make a fair, full, and final determination of law in this case. The plaintiff's declaration states that he was crossing the street at Elm, Maine. No one disagrees. It further states that as he entered the street, the defendant's truck hit him. No one disagrees. The facts are clear. The only thing left to do is determine whether or not the defendant was negligent, an issue of law. Your Honor, both sides have put forth detailed evidence in the declarations attached to our motions. The arguments have been set forth, and it would be a clear waste of time and money for the court and everyone involved to start dragging witnesses into the court for each and every point in the case. Adams. Your Honor, I should not be deprived of the right to cross-examine the plaintiff and his witnesses. My affidavit indicates that he ran out in front of my truck and that I was watching the road carefully. The plaintiff wants you to decide the matter on the papers so his story will not be exposed to cross-examination. But my right to a fair trial will be denied if you grant this motion. Your Honor, I renew my request that you deny the motion and that a trial date be selected. Judge. In light of Ms. Adams' arguments this morning, and given that it appears there are significant issues of fact and credibility, I have decided to deny the plaintiff's motion, and the matter of Pedestrian v. Adams will proceed to trial. The clerk will notify you when a trial date has been selected. So, a resource you might be interested in is American Jurisprudence, Pleading and Practice Forms Annotated, which is a comprehensive multi-volume treatise with discussion and examples of many different kinds of pretrial motions. Also, Pretrial by Thomas Mowat M-A-U-E-T. And that is it for our section today on pretrial motions. Next video 8 will be proving your case at trial, the plaintiff's perspective. We will be going over the elements of a legal claim, a negligence claim, breach of contract claim, legal malpractice claim. We'll be discussing finding the elements of the claim, of your claim, proving each element, your burden of proof, identifying facts to prove the elements of your claim for each one of those points of the claims of negligence, breach of contract, and legal malpractice, looking ahead to trial, organizing your evidence, and learning about your adversary's case. So let's stop the screen share. And just want to once again thank you for joining us here today in this video series, and for taking the time to educate and empower yourself in the category of law, which is applicable in so many areas of life. We encourage you to share with your friends and form study groups together to study law, and that is how that we can most effectively remedy the problems that so beset this world, and the injustice and crime that we see in high levels of government. We can address these matters lawfully by convening common law grand juries, and through due process, as we are learning about here, we can force criminals and criminal activity to cease altogether. So thank you again for taking the time to be with us here. My name is David Bryson, and until we meet again, be blessed.